now, the federal judge overseeing the 2020 election interference case against former President Trump is hearing arguments from both the special counsel's team and Trump, along with attorney Paul Henderson. Tom, what are we watching at this hearing?
Right, so our colleague Daniel Barnes is sending us some notes from this hearing and says that apparently the judge just said, Mr. Trump, like every American, has a First Amendment right to free speech, but that right is not absolute. She says, and we're paraphrasing here, in a criminal case that free speech is subject to the release conditions imposed at arraignment. You remember that the former president had to sign some of those conditions about a week ago when he was before the court. And she says, without a protective order to on disclosure of discovery materials, could lead to witnesses being harassed or otherwise interfere with a fair trial. So that's what she's discussing at this point. The hearing began at approximately 10:01 this morning, and apparently they are hoping to, or the judge is hoping to make a decision on this perhaps as soon as today. It doesn't sound like she's going to rule from the bench. She'll put an order onto the court docket, but we do anticipate getting some resolution on this today on this issue of the protective order. Back to your original point, and when we were starting off here, it's about two things. Sounds like the judge is starting to address the former president's ability to speak publicly about this case, as well as the idea of the protective order, what types of things from evidence the former president can talk about. So Trump, in his legal defense team, will get the discovery and will get the evidence that the government intends to present at their case, what prosecutors intend to bring up whenever this trial may happen. They'll get any sort of information that might be beneficial for the former president at that time. Protective orders, I was thinking back this morning, I don't think I've ever done a report on a protective order, but it just shows how much attention is being paid to this case. But it also shows the idea that both sides are really dug in here and are litigating all the finer points. So federal prosecutors want to be able to show their evidence at the time and the place that they're choosing and the manner they're choosing. The defense, and this is not uncommon, by the way, perhaps want to put some information out and raise some points about some of the things that are in this indictment. For instance, the Cheeseborough memos, if you look at those, the New York Times has published them. You look at the one on the 6th that apparently was used in the indictment, it paints a certain picture. If you look at the one on the 9th, it might paint a different picture that might be more favorable.
We believe is one of the co-conspirators, but unnamed.
Exactly, and this has to do with what prosecutors call the fraudulent elector scenario. So that's just one example, and I think that's going to be something that both sides are, they're clearly fighting hard over, and we'll continue to get
it doesn't sound like at this point the prosecutors are asking for a full gag order, so they're not trying to stop the former president from speaking, which is important, I think, to underscore here.
Exactly.
But they do want to protect potential witnesses from being compromised or any kind of intimidation from happening here.
Exactly.
And so, Paul, if you remember, in a rally just a couple of days ago, Trump was talking about this proposed protective order, and he said, quote, "I will talk about it. I will. They're not taking away my First Amendment rights." Is that a comment the judge will take into consideration as she hears these arguments?
It is, and I believe that's absolutely why she started with his First Amendment rights and talking about the decision that she's going to make. She was making it very clear that First Amendment rights are not absolute, and First Amendment rights are not balanced when there are criminal trials every single day, especially when those comments, those words have an effect, and a legal effect. So you don't have absolute First Amendment rights anyway. The fact that he is talking about it publicly, I believe it's encouraging to me that the judge is paying attention to what prosecutors are filing and talking about the issues that they've raised in a legal context in preparation for her decision that I believe is going to affirm the protective orders in ways that is more similar to what the prosecution is arguing, especially in a case like this. These issues that we're talking about with protective orders take place in every single criminal case. They are more especially prevalent when we have a grand jury and a case coming from a grand jury. Because in the case, and even in this case in particular, where you have elected officials, you have official documents, you have privileged conversations and protected witnesses. And we know that Trump has attacked witnesses in the past and made their information public. This isn't something new or speculative. We've seen behavior like this where people that are doing their everyday jobs, and not just civilians. So in a case like this, he has attacked investigators and agencies as well. So if there's information from the CIA, if there's information from the FBI, that's not a bar for him to make public statements to denigrate those individuals and those agencies These are all the reasons why these arguments are so important and this ruling is so important, but it's also another indication of just how Trump is going to attack his case as his defense and try and raise every issue that he can to delay, to obstruct, to derail the prosecution that's taking place. But this is almost a no-brainer, and I would be very surprised if the judge rules in another way that doesn't protect and affirm the protective order as affirmed by the prosecution in this case with Jack Smith.
The thing, though, that makes it more complicated, I suppose, is the fact that this is a defendant who is running for president and is in the middle of a campaign and is, in fact, the leading GOP nominee frontrunner right now. I want to bring in former federal prosecutor Brandon Fox as well to this conversation. Brandon, Trump's already pushed the envelope more than just about any other defendant. He's posted sometimes threatening content on his social media. He's railed against the Justice Department, the special counsel, even some judges involved at almost every rally he goes to. He seems to have no interest in abiding by any protective order imposed. So if you're the judge, how do you handle a defendant like this?
Well, and this goes back to some of what Paul was talking about. This protective order is more about a fair trial and more about protecting witnesses than it would be about sensitive information, because typically in federal prosecutions, you're talking about sensitive information like bank records, grand jury transcripts that you don't want to leak because there's an ongoing investigation, which may be the case here. But really, this is about not wanting Mr. Trump to be intimidating witnesses, not wanting him to be out there potentially making it so that the jury pool is not considering the evidence and considering other things. So the judge really, it's a good early test for her to see if she's going to treat Mr. Trump like she would any other defendant. And if he still goes out there and he still has his social media posts, which she might believe would be intimidating witnesses, what does she do at that point? It's a great early test.
I mean, what does she do?
Well, I mean, I hate to speculate on anything like this, but, you know, for any other defendant, what would happen is there'd be a warning. There'd be an admonishment. She'd bring in the defendant. She'd ask questions. What did he mean by these social media posts? Really put it to the defendant. And then from there, her options are to further restrict his conditions of release. And at some point down the road, have to make a decision if they're not going to abide by that. Is this person entitled to still be out on a release pending the trial? But we're so far away from that area, I don't want to speculate about what that would take.
And you have more reporting coming from the courtroom, Tom?
That's right, Anna. So our colleague Daniel Barnes says that Thomas Wyndham, who's one of the lead prosecutors for the special counsel's team, is making the case, or trying to make the case to the judge, that all discovery in this case should be protected, and so that the president, the former president, and his attorneys should not be able to put any of it out into the mainstream, into the public. The judge is challenging that, saying, well, what about just certain sensitive pieces of discovery? Shouldn't that be restricted and the rest could be out there? Wyndham making the argument, according to Barnes, that the defendant's proposal, that would be Trump, a proposal specifically tailored to permit them to try this case in the media. Apparently, he also said that the defense is asking for the court's blessing to use criminal discovery for political purposes. So that's what we're hearing from the lead prosecutor for Jack Smith's team.
I'm so glad you have this reporting that you can bring us, because we can't see inside the courtroom. I mean, the federal cases don't allow cameras in court, so we're forced to have to kind of do this sort of game of passing notes and then reporting out on air. Brandon, let's pivot here and talk about the trial schedule, because as we mentioned, the special counsel's office wants the trial to start January 2nd. They believe it could last 4 to 6 weeks. Does this sound realistic to you?
Yeah, that seems like it's the right length of the trial. Now, they said that's for the prosecution's case. I would expect that would be for the overall case. It's about how much it would take. I thought what was the most interesting part about the January 2nd pick that they have, and we'll see if the judge orders it, is it says, forget about the defamation case. It's the end of January. This case is more important. And it is really Jack Smith's office bigfooting a little bit, saying this case is the most important thing, and the civil case can fall to the side that is set at the end of January. So I do think you actually can fit this in. I think 4 to 6 weeks seems like a realistic expectation for how long this trial would go. And as Jack Smith's office put it, it is in everybody's interest for this case to go first before the voters have to decide who the Republican nominee will be and into the general election.
See, it's simple enough if you're looking at just one case and one trial. But as we just showed with that graphic, there is a lot on Trump's plate. And he was quick to post on his social media, call the proposed schedule, quote, election interference, because this timing, of course, keeps him off the campaign trail, at least in part. Paul, the Iowa caucus is on January 15th. You have another E. Jean Carroll defamation trial the very next day. Can we put that other graphic back, guys? He's back in court to face class action lawsuit for business fraud allegations there on January 29th. New Hampshire's primary right around then it's on to Super Tuesday on March 5th. So you can see how backed up everything is. Paul, what does all that mean for scheduling this trial at any point?
Yeah, I think what you're going to see is a wave of these charges and indictments overtaking the campaign trail that he's on. And this is before we start having an in-depth conversation about what's happening in Georgia and that fourth indictment that we're expecting any week. And the reason that one I think is going to be the one to watch in all of this, because it is the disruptor. They have making no accommodations and coordination with the federal charges. And that means he's going to be treated differently in the court. They expect him to be have a mugshot and go through regular criminal processes. They're not giving him federal accommodations as he's experiencing in other cases. These will be all new charges. The other interesting thing is that some of that evidence from the Georgia case that involved the Secretary of State will be part of the federal charges that he's facing right now. And remember, these are state charges, so there's no pardon that's possible regardless of whether or not he becomes the ultimate nominee and even if he ultimately wins the presidency in the future as well. I think all of these things are going to overwhelm his candidacy. I think all of these things are going to interrupt the run that he's making. And soon there's going to be a shift into these mounting hearings, mounting decisions, and mounting sentences is what it's looking like, where we're headed. That's got to overwhelm what he's trying to do as a candidate. I think that's just the reality. Again, none of this prevents him from running. None of this prevents him from potentially winning if he has the votes. But I think it's going to be a real distraction, not just to him, but to the public as well, that is watching all of this to see that day after day, beyond just what he's saying on the campaign trail, there are legal repercussions and legal obligations from him and his team. That's what I think is going to happen.
This is a historic moment we are in right now. All of you, thank you, Tom Winter, Brandon Fox, Paul Henderson.